bring myself up to speed.
Oh, sorry. You ready?
You want to go first or shall I go first?
Yes.
My lords and my lady, we've reached agreement on 2 points. The first is that these Christians, having been raised, in our respectful submission, the Court of Appeal cannot resolve the appeal without these Christians having been answered, and that means of necessity that we can't proceed today, not least because these arguments will need to be addressed in the presence of the receiver of rec and with the involvement of the receiver of rec. So the practical question is, where do we go from here? As we see it, there are 2 possibilities. Your Lordships may think of more. The first possibility is that the matter is effectively a retrial is ordered in front of a different Admiralty judge, because it can't go back to this judge because he's formed views already on Section 10, which in a sense he can't undo. And the issues which have been raised on this application, as well as the issues that have been raised by the court, would be resolved in that context. Now, quite how we bring in the receiver of rec, those sorts of practical questions, we haven't been able to resolve in our minds yet. The second possibility is for the Court of Appeal to hear the further issues at a adjourned hearing, in a sense pick up from where we are now and adding in those issues for resolution at the time. And at the moment we're not agreed between us which of those would be the most sensible procedure to adopt, and what we're requesting your Lordship and your Ladyship is to have until 2 o'clock in order to seek to consider those matters. But your Lordships and your Ladyship may, of course, have observations to make already along the way.
Well, one observation is that perhaps the key to the question is the receiver, Mr. Caldwell, is it? I think that's the identity we looked up of the receiver.
Our understanding is it's a lady.
Well, I think it was a lady in 2020.
Ah, right, it's changed.
I think it's changed. But anyway, don't worry about that. That's just a sort of point of interest. The receiver's position is important. And if you had until 2 o'clock, one thing you might be able to do is to talk to the Treasury Solicitor, the Government Legal Service, about their involvement. I must say my initial reaction, without seeing my colleagues' initial reaction, is that to send it back to first instance for another determination of something that we are seized of is actually a little strange, because the first instance judge, if there were a new one, might reach a different conclusion on the Section 10 issue, whereas that's not really an appropriate way. So if we could retain it in this court, I think that would be the better solution, provided we have the necessary argument and we're not being asked to determine facts that have not been determined.
I have to say, speaking for myself, I very much provisionally of that view. The issue that we've got to decide, the issue which the judge decided, I think remains the same. It's just that it involves ramifications on which we haven't had argument, on which we would like to hear further argument. I would put it in that way.
Yes, and we'd probably want to direct you to agree issues, including the present issues, because I'm not sure we ever did have a proper list of issues, so that, and then you would have to file further skeleton arguments. But as I say, the key to it really is whether the receiver would want to come in and be represented as an intervener. And I think, for speaking for myself, and again, subject to anything my colleagues may want to say, if you take until 2 o'clock to consider the way forward, which would seem to be sensible, and you're able to contact the receiver, which you may or may not be able to get a sensible answer out of them in this time, but you could at least say the court provisionally would invite them to participate in the proceedings as an intervener, unless there were good reasons why that was not appropriate. That, I think, would be something we could say for them to consider.
An alternative might be that they should be provided with your further submissions and given an opportunity to either intervene or to put in a submission in writing.
Yeah, I mean, they could choose.
There are different sort of procedural formats, and it may be you won't get a sensible answer by 2 o'clock as to from the Treasury solicitor as to exactly what is intended, but that's something for you to sort out.
The reason that I hesitated in relation to this court potentially continuing is because, well, firstly, I wasn't involved in this period of the chronology, as it were, so I'm not steeped in it. When I became involved, I asked these questions, and that was history at that stage. And so I'm not familiar with the detail of it, and I'm going to need help with that from those behind me. But there is a long history, and there was a request made for the matter to be dealt with in the way in which the court is now dealing with it, and that was resisted very strongly by the Republic.
Right.
And again, I stand open to correction in all of this because I've not. Well, there we go. I'm already.
Shall we hear from Mr. Smith on that point?
Yes, certainly. But at least there is undoubtedly a long history, and there has undoubtedly been a reservation of positions, I think, by both parties. In order to work out how best to present these issues, it may be necessary to review that correspondence carefully.
Well, that's why you can take a little time to do it. Mr. Smith, do you just want to tell us what has happened that we don't know?
Well, the only reason I was slightly disagreeing with the way my learned friend described the position is that I don't think it's accurate, and I would need to refresh my memory of the correspondence to say that a suggestion was made to deal with this way and we resisted it. There was at one stage a suggestion that the receiver of Rex decision could be subject to a judicial review. And we resisted that simply because the suggestion was not made till the time limit for a judicial review had expired. And so we would need to reconsider whether there was a point in relation to that or whether there was another method by which the receiver could be brought to court. And my learned friend and I think this is a fair way of putting it, both see the value of identifying the appropriate method to bring the receiver of rec before the court, even if only to agree with one of us or the other of us. Whether he wants to make submissions or not will be a matter for him and the Treasury solicitors. But we both
we've suggested two methods by which that may happen: inviting the receiver to intervene, or allowing the receiver simply to be shown the submissions once they've been prepared and comment on them if they want to in writing, and then apply to join orally if they want to as well.
And another that had occurred to us, I think, in our brief discussion, was the possibility of the receiver being joined as an additional party, and a declaration sought as to the extent of their powers, and then leave it to the receiver as to whether to oppose that. And that would create a list between, create an issue between my learned friend and I that would then be the appropriate form, perhaps.
Yeah.
There are a number of possibilities, but we both felt that if we had till 2 o'clock,
Yeah. Well, I
with
think
some
you also,
goodwill, which
in
there
that
is.
period, you should consider mapping out a draft order that would give you both permission to amend either the notice of appeal or the respondent's notice or both, to agree a list of issues, a timetable for further submissions, and then an indication as to how long the further hearing would be, on the assumption that there may be a third representative, I think. And that order would also then include provision for attempting to get the receiver involved if they wanted to be involved, if he wanted to be involved.
And indeed, my lord, potentially a fourth other party involved if the Human Rights Act issues became significantly engaged in terms of incompatibility.
In terms of
Incompatibility between if there was immunity that was incompatible with the Act that couldn't be avoided by a reading down, then that issue might arise. So certainly that's something we have in mind that we want to take into account over the next 2 hours as well.
Yeah, very good. Well, I'm perfectly happy with that. All right. Well, then, sounds as if you've got a bit of work to do. So we'll resume at 2 o'clock and see how far you've got. But many thanks for your constructive approach thus far.